Hello, everybody. Good afternoon. My name is Cassie Pajarillo Braganza, and together with Disini and Disini Booted Disini Law Office, we wanted to welcome everybody who's joining us today's webinar. And today's Doing Digital Business. We are going to be talking about doing e-businesses, electronic contracts, documents, and signatures. So as the new normal sets in, it has become essential to conduct businesses electronically. To celebrate the 20th year of the ECommerce Act, which recognized the validity of conducting business online, we will discuss electronic contracts, specifically the legal recognition of electronic documents and electric signature. Although we are going to be learning more on terms of how it's being executed, we are also going to be talking about how is it proven in court through the rules of electronic evidence. So again, today's agenda, we are going to learn the basics of E-commerce Act and the basics of the rules of electronic evidence.
Sorry, good morning, good afternoon to everyone. Thank you for joining our webinar today. And so we will be discussing doing business electronically, which has become sort of a priority issue for a lot of businesses right now, electronic contracts and electronic documents and electronic signatures. So coincidentally, this is in celebration of the 20th year of the E-commerce App, which provides the legal basis for much of what we will discuss today. Okay, so what will we discuss today? So first, we will discuss the E-commerce Act and the legal recognition under the E-commerce Act of electronic documents and electronic signatures, as well as some points about electronic contracts and how to enter into valid electronic contracts. And then we will also discuss electronic evidence basics, because the rules on electronic evidence were enacted by the Supreme Court, promulgated by the Supreme Court the year after in 2001. And actually, we are very fortunate in that the firm was involved in the drafting of the implementing rules and regulations of the E-commerce Act, as well as co-drafted or participated in the drafting of the rules on electronic evidence 20 years ago in 2000 and 2001 respectively. So we'll just jump right in. No? So the first topic, of course, is the E-commerce Act. And of course, the objective of the E-commerce Act is to provide a firm legal basis for electronic commerce. So back in pre-E-commerce Act, the big question was, if I enter into a contract using email, would that be enforceable? Would the law recognize it as valid, or will I have problems? Can I have it introduced into evidence? Can a court enforce it? And the bottom line is that around all of these issues, there's always that concern. But actually, the law already validated all of these things. But there's nothing like an express provision in law that says it is electronic, it is recognized, these types of contracts in electronic form are recognized, and the courts will enforce them. And that was what happened with the E-commerce Act. Now, the E-commerce Act was supposed to apply not only to, actually originally, as you take from the title, it's only supposed to cover electronic commerce. And indeed, our E-commerce Act is based on the UNCITRAL model law on electronic commerce, which was only supposed to cover business transactions or commercial transactions. However, in the Philippines, it has been expanded to cover also non-commercial transactions, and even things like family law and even wills. So you can have a will done electronically. Of course, it's tricky, especially in a notarial will, because we have no provisions now validating electronic notarization. Also, 20 years ago, the government or the E-commerce Act provided for e-government, and in fact required all government agencies within, I believe, 3 years from the passage of the law to allow filing of electronic documents as part of required the filing of electronic documents as far as they are transacting with citizens. And also, one of the most significant provisions of that law was the enactment or criminalization of hacking or cracking. This is way back in 2000. And in fact, at the time that the E-commerce Act penalized hacking or cracking, the Philippines had the most the most effective or the most modern, one of the most modern laws on cybercrime, because one of the things that we penalized under the E-commerce Act was the act of interfering with the operation of a computer system, and that covered distributed denial of service attacks. And at the time that the law was enacted in 2000, I think the Philippines was only one of maybe 2 or 3 countries in the world that punished this as a crime. Okay, so just some basic principles, principles that underlie the E-commerce Act. First is the functional equivalence principle. In other words, the idea here is that anything in electronic form that performs the same function as a document or a signature will be considered that equivalent in the real world. So, for example, a signature, the purpose of the signature is to identify the person, and it's adopted by the person in order to indicate that person's consent, right, or authentication of a document. And therefore, anything in electronic form that performs that function, that identifies the person, that the person can adopt, and indicate his consent to a document, will be considered as an electronic signature, and therefore functionally equivalent as a handwritten signature. The second principle under the E-commerce Act is technology neutrality, or in other words, the law is supposed to be technology neutral. In other words, it should not favor one particular type of technology, okay? And therefore, it should admit all types of electronic documents that satisfy functional equivalence as equivalent of a written document, and in much the same way, accept any kind of electronic signature as a valid electronic signature. That at least is the principle. Of course, the implementation is different, as you will discover later. The third is media neutrality. In other words, since what is protected is information, then so long as that information transfers from one media to another, from a scanned document to an SMS, from an SMS to a fax, from a fax to an email, all of that, all of those are now considered part of the E-commerce Act and covered by the statute. And lastly, of course, is the principle of non-discrimination. And in non-discrimination, the law is not supposed to discriminate between paper documents and electronic documents, between wet signatures and valid electronic signatures, as recognized under the law. Okay, so what is the purpose of the E-commerce Act? The way that it operates is that there is legal recognition of electronic documents, electronic signatures, and of course, electronic contracts. So let's start with electronic documents. So in the E-commerce Act, an electronic document is defined as referring to the information that is generated, sent, received, or stored by electronic, optical, or similar means. So now you see that it's a very, very broad definition of what is considered an electronic document. What's interesting is that there is a Supreme Court decision where the Supreme Court, the Philippine Supreme Court said, and looking back at the Senate proceedings for the E-commerce Act, where the court said in that case that faxes are not considered electronic documents. Okay, this is because during an interpellation of Senator Magsaysay by Senator Miriam Defensor Santiago, she procured from him, right? She was asking her a series of questions. Of course, she's a lawyer, and she must have intimidated Mr. Senator Magsaysay, who is not a lawyer, and asked a lot of questions. And at the end of the discussion, the sponsor of the bill, Senator Magsaysay, relented and said that faxes are not part of electronic documents, or the definition of electronic documents. And on that basis, the Supreme Court held that faxes are not intended to be part of electronic documents. However, I think the problem with that decision is that the language of the statute is very clear, that so long as the information is generated, sent, or stored by electronic means, in other words, if it is merely sent by electronic means, then it is considered an electronic document. And therefore, there's reason to believe that the Supreme Court did not follow, or I think should have followed, the express language of the statute. Also, I think the other thing to consider was that the language that of the statute, or the basis of Senator Miriam Defensor Santiago's questioning or interpellation of Senator Magsaysay, was that she was reading of the Canadian law, or counterpart of the Electronic Commerce Act. And in the Canadian law, faxes are excluded. So therefore, it was as if they were talking in that exchange with the Supreme Court references. They were talking apples and oranges. They were not talking about the same thing. I think if Senator Santiago wanted to have a discussion with Senator Magsaysay about this issue, she should have stuck to the definition in the UNCITRAL model law. Okay, so how does the E-commerce Act recognize electronic documents? And it does so, as we've quoted here, in the negative. And it says that information, so remember, the electronic document is the information itself. It's not the electronic file. It's the information contained in the electronic file. Okay? And so the information, this information or electronic document shall not be denied legal validity solely on the ground that it is in the form of a data message or an electronic document. So that is a recognition that it is supposed to be treated at the same way as electronic, written documents. And really that is the meaning of legal recognition. Legal recognition means that electronic documents, when something is in an electronic document and it satisfies the E-commerce Act in terms of integrity and reliability, then it is equivalent to a writing. In other words, anywhere in the law that requires that something be in writing, it may now be in an electronic document. Okay? And these are examples, right, under the law where certain documents must be in writing, such as documents falling under the statute of frauds. Negotiable instruments, for example, need to be in writing and also signed. And of course, marriage settlements. So these are examples. An electronic document now can satisfy these requirements in order, right? In other words, if there is a verbal agreement and it is not yet performed under the statute of frauds, if that agreement can be documented by SMS messages, by emails, then it would be considered in writing. You will satisfy the statute of frauds, and therefore the contract will no longer be deficient. In the case of electronic signatures, what's interesting is that there is a disconnect between what the law defined as an electronic signature and what it finally recognized. So the definition, as you will see here, is very, very expansive. And in fact, the definition satisfies the functional equivalence principle in the sense that any mark, right, any mark representing the identity of a person and attached or logically associated with an electronic document, if it is adopted by the person, right, and with the intention of authenticating or approving a document, then that electronic mark or distinctive mark is considered an electronic signature and therefore satisfies the definition of an electronic signature. Now, question, is that electronic signature, are all types of electronic signatures that fall under this definition, are they legally recognized? And sadly, the answer to that question is no. That in fact, the E-commerce Act only validates a small subset of electronic signatures, and that is governed by this provision. This is Section 8 of the E-commerce Act, and I've quoted here in full because it is, in fact, a very complicated statute, right? So it refers, all of these things have to be present, right? Before the signature, the electronic signature, is considered legally recognized. And what do I mean by legally recognized? It means that it is the equivalent, that electronic signature is equivalent to a wet signature or a handwritten signature, such that the document to which that electronic signature relates or is associated to is considered signed under Philippine law. So if something needs to be signed under Philippine law for it to have some significant legal effect, then that document must satisfy these requirements of Section 8. Now, a good example, for example, is a negotiable promissory note. So negotiable instruments law requires that negotiable instruments must be in writing and signed by the maker or drawer. If there's anybody out there who's a student of mine in negotiable instruments, which I've been teaching for about 20 years, you will know this provision well because I ask you to memorize it. Okay, so what is an electronic signature? What are the requirements in order for that electronic signature to be equivalent to a handwritten signature? So let's go to the first one. It says it is a method, right, unalterable by the parties, and a method is used to identify the signer and to indicate that signer's access to the document. Second, the method is reliable and appropriate for the purpose for which the electronic document was for which it was generated. Okay, it is necessary for the party sought to be bound to have executed or provided the signature. And finally, the other party is authorized or enabled to verify the signature. Now, this is a lot. And back in 2000, when we were analyzing this, about the only thing that we could see that satisfied all of these requirements is a digital signature within the context of what's known as a public key infrastructure. So that's a mouthful, and we will unpack that next week when we talk about electronic signatures. Okay, so questions, right? First, what about scanned signatures, or what I call digitized signatures? In other words, you have your signature, you scan it with the scanner, you store it in your in Microsoft Word, or maybe you store it as a JPEG, and when you're going to sign a document, you cut and you paste it on the document. Is that a valid electronic signature? So first, is it an electronic signature? Under the definition of the law, yes, it will satisfy as an electronic signature, but is it a legally recognized signature? Sadly, no. Why? Because the requisites of Section 8, as I mentioned before, I'll bring that up again, they don't satisfy these requirements. In fact, there's a way, and I use this all the time, where you can scan your signature on Apple Preview, and even have it on your phone. And when somebody sends you a PDF, you can sign that document, right, using the functionality there. And it's an image of your signature, and you can even have a color to it. So you can use blue, you can use red, and then you can sign that document. So the document would not be considered signed, but that would be an electronic signature. Okay, so those kinds of documents, when you just slap on an image of your signature on an electronic document, it is not considered as an equivalent of a signed document under the law. Now, of course, there are other technologies out there. DocuSign is one of them. Adobe Signatures and Tiwala. Tiwala is a locally developed electronic signature system, and we actually hope to invite a representative to talk about Tiwala next week. And in those cases, I will reserve any comment right now. Tune in next week to find out. And finally, of course, as I mentioned, digital signatures under PKI would be considered valid in the Philippines. And there's some interesting thing going on right now. The Department of ICT is has set up actually a digital signature system, which it has offered to the government. And the big question now is, would those signatures be considered equivalent to handwritten signatures under Philippine law? We will discuss that next week as well. Okay, now, what about unilaterally signed documents? This is quite interesting, because if you go back to the definition, if you look at the last requirement, I don't know if you see my mouse, the last requirement, which is the other party is authorized and enabled to verify the signature. So what this implies, right, what the law implies is that there are two parties to the signature, the signer and the other party. So the question now is, what about a unilateral document, like a certificate or maybe an affidavit? In other words, there are no two parties, it's not a contract, it's merely an authentication of a document by the signer. Would that be covered by Section 8? And my view is yes, it would be covered, and that the other party, right, referred to in Section 8, would be not a counterparty as in a contract, but any party who is interested in verifying or authenticating that document would be considered that other party. In other words, any party who's interested in the truth of an affidavit will be authorized and enabled to verify the signature. Okay. And then finally, of course, and this is a big issue right now for lawyers, what about notarized documents? Are notarized documents covered by the ECommerce App? Sadly, no. But there is authority on the part of the law given to the Supreme Court to enact rules on electronic notarization. And in fact, Chief Justice Peralta recently constituted a committee to propose rules on electronic notarization. And this is a major issue because a lot of documents are required to be in public form. And of course, the reason why notarization is popular or almost always required by your lawyer is because there are evidentiary advantages of presenting a notarized document. A notarized document under our rules on evidence is a public document. And we don't need, as lawyers, to authenticate it anymore. All we have to do is prove the existence of the notarization, and immediately the document is admissible in evidence. And that's the reason why your lawyers require your documents to be notarized. Now, this now is a list of documents under the law which must be signed in order to have some validity. In other words, like for example, a holographic will must be in writing and signed. Right? So the question now, what kind of signature? That signature has to satisfy Section 8. And if it doesn't satisfy Section 8, then you cannot have a holographic will. You cannot have these other things that are required in the statute. So one of the questions I think, or one of the concerns when it comes to electronic signatures is that, well, if there is limited recognition, is that bad from the standpoint of electronic signatures, or does that mean that we cannot enter into electronic contracts? Well, the good news is that the number of documents required to be signed under Philippine law is actually quite small, right? And therefore, in other words, contracts that have to be signed in order to be valid, there are only few contracts that fall under that category. And therefore, if you don't fall under that category, it doesn't matter whether that document is signed or not signed, right? Because it will still be valid under Philippine law. And we will discuss that a bit later about what the elements are of electronic contracts that are legally recognized, which brings us here now to this part on electronic contracts. And therefore, how did the e-commerce Act recognize the validity of electronic contracts? Essentially, what it says is that so long as the offer and acceptance, right, and these are what is known as the external elements, right, the external manifestations of a contract. So long as the offer and acceptance and other elements required by law are embodied in an electronic data message, right, then they may be used to prove the existence of an electronic contract. Now, this is consistent with Philippine law, because Philippine contract law says Philippine contract law follows what's known as the spiritual system. In other words, contracts are valid in any form that permitted. So a verbal contract, an oral contract, for example, is considered valid under Philippine law. And therefore, you don't need a writing to do that, okay, or written document to do that. Now, so question, for example, what if you send an email? Let's say I send you an email or an SMS, and I say, if you want, you can buy my car, and I'll mention my car with the plate number, and I'll say, I'll sell it to you for 300,000 pesos. And you send an SMS back or an email back saying, okay, I accept. Now, that's the offer. My first email is the offer. The SMS message or the email message back is the acceptance. And both documents now, both electronic documents now, are proof and can be used as the basis to prove the existence of a contract. Okay, so that is one way in which you can enter into valid contracts by direct message, chat. In fact, there is a case in the U.S. very interesting where that it was a chat, right? And on that chat, they amended a contract, which resulted in a ceiling of $5,000, resulted in a liability of about $1.5 million, about 1.5 million US dollars, all on the basis of two words in a private message, basically said no limit on the amount that they would book. Okay, so there's another type of contract which is very popular back in 2000, and actually to a certain extent it's still true now, which is known as a browse wrap contract. And under these types of contracts or terms of use, it says, now if you read, I don't know if you bother to read the terms of use in websites, it says that when you visit our website, the mere fact that you access the pages, you are now bound by our terms and conditions. I remember back in the early aughts, there were newspaper websites in the Philippines, news websites, which had this provision. And therefore, if you go to their site, immediately you are bound by their terms and conditions. And if you don't follow their linking policy, it used to be that you could not link to the story directly. You can only link to the home page. So if anybody violates that, they said you violated our terms of use on the basis of, because you browsed through our website, you are now subject to those terms and conditions. Okay, so that's one type of contract. And the question now is that a valid type of contract? And the answer to that question was answered way back in 2000 also, in the US case of SPEC versus Netscape. And in that case, the court recognized that when you have a browse trap contract, or when you merely surf to a website, you're not even aware that you're entering into a contract. Because you're not aware you're entering into a contract, how could you be bound by terms and conditions set, right, unilaterally by the owner of that site? And therefore, these types of contracts are considered not valid. So if you want to have a valid contract on your website or on your app, what you need to do is what the court referred to as a click-through contract. And in a click-through contract, this is one where there's a window that comes up, the terms and conditions are presented to you, and at the bottom, you click a button that says, I accept, right? I'm sure a lot of you have seen that type of contract, and I'm sure a lot of you, if not maybe 99, or maybe all of you, none of you have read those terms and conditions. Even I actually, if I'm just going in, I don't bother to read it. I just click on the buttons and I click, and that's called a click-through contract. And the validity of that has been upheld. In fact, there were a number of cases in the US involving arbitration clauses that were embedded in these click-through contracts. And the courts required the parties to go through arbitration because the click-through contract is a valid mode of contracting. Okay. What about contracts that are unsigned, right? Should we be worried about them? Well, the answer for that is no, because unless the law specifically requires that a signature is necessary for that document to be valid or that contract to be valid, then, as I mentioned earlier, so long as the elements of the contract or the offer and acceptance are in an electronic document, they would be considered valid. Okay, in the case of unauthorized documents, contracts, we discussed that already. Okay, so I'll just move quickly now, just very briefly to the rules on electronic evidence. Then we can go to our Q&A, and I think there are a number of questions that are already up there. I hope you guys have prepared, you have a lot of questions for us. So on the rules on electronic evidence, so this was about a year after the ECommerce App, maybe 6 months after the Supreme Court constituted a committee, and our chair was retired Court of Appeals Justice Elvinas. And he led our team. We were Francis Lim of Accra was there, myself, Lito Averia, Abet de la Cruz. So we put this thing together, and we came out with the rules on electronic evidence, which the Supreme Court enacted. And initially, actually, it only covered civil cases and not administrative cases, but not criminal cases. Okay, so there's some few misconceptions about electronic evidence. So first, that electronic evidence, even back in 2000, right, was new to the Philippine legal system. I will argue that that even long before the ECommerce Act was enacted, evidence of electronic, optical, etc., those things were already considered admissible. What created, I think, the confusion was there was a case involving IBM where back in the 90s, IBM had an email system, an internal email system. And then there was an employee who was not performing well. So the employee received notices, right, saying, I think it was about concerning attendance, right? So this person was coming in late, and a lot of email evidence was sent there. And in fact, the notice, the two notice rule, to satisfy the two notice rule to terminate, both notices and even the notice of termination was sent by email. So this was, the person filed an illegal termination case against IBM. And, in labor cases, it's before the labor arbiter, and there is a, what you call a position paper before the arbiter. The counsel for IBM attached all of the emails as an attachment to the position paper. Case went all the way up to the Supreme Court. And the Supreme Court said that the emails were inadmissible as evidence. Now, and this is where the confusion started, because it created this perception that that electronic mail or email is not admissible in evidence. But if you read the case closely, what the court was saying was that it's not that the email was not admissible, it's the fact that it was not authenticated. Because under the rules on evidence, if you're going to submit a document, you must authenticate it. So what was missing was those emails, because they were printouts, should have borne a stamp and a signature of a company representative saying that this is a certified true copy of the email that is within their system. Because if back then they could not, I'm sure there was no remote access that they could have done within the labor arbiter's office. Okay, so electronic evidence, the rules on electronic evidence and the E-commerce Act did not make evidence admissible. Even documents prior to the time that were in electronic form were already admissible. In fact, I look at the rules on electronic evidence and even as an E-commerce Act as merely confirming, right, explicitly confirming the fact that electronic documents are recognized, are valid, electronic signatures are valid, and confirming that electronic evidence is admissible. Okay, and as I mentioned earlier, the rules on electronic evidence does not allow notarization, electronic notarization, nor electronic filings of pleadings, which is something that the Supreme Court now is also looking into. Neither is the rules on electronic evidence the final word on electronic evidence. And in fact, the new amendments, the rules on evidence, adopted some of the things that we put into the rules on electronic evidence, particularly the duplicate, the counterparts provision for the best evidence rule. Okay. Also, there's some perception, which is not true, that the rules on electronic evidence does not apply to criminal cases. So originally, when the rules were enacted, the Supreme Court did exclude you could not use electronic evidence in criminal cases, but that only lasted for a couple of months, and the Supreme Court quickly amended the rules on electronic evidence to include criminal cases. In fact, this has also been confirmed by the Supreme Court. Okay, so how do you present an electronic document? Well, the shortcut is a printout. You take an electronic document, you print it out, it is considered the best evidence, or that is the original that you will present in court. But not the printout, but you also have to show that it reflects the data accurately. So a simple way to do that is you have the printout and then you compare it to the electronic copy. Now, what some lawyers do is they even attach the soft copy, they burn it on a CD, and they present that soft copy to the court as well. Okay. Another type of original is what's known as a duplicate original, or a counterpart which accurately reproduces the original. And actually, the intention here is to include things like photocopies. So a photocopy now is really supposed to be the same as an original. Unfortunately, there is a Supreme Court case involving the National Power Corporation, NPC. I believe it's NPC versus Codilla, where the Supreme Court held that photocopies are not considered duplicate originals. But interestingly enough, this duplicate original rule is now part of the rules on evidence. And one of the big questions, I think, moving forward is whether or not photocopies will be considered as being equivalent of the original. It used to be, the general rule under the rules on evidence that if you're going to present a document an evidence, you have to show the original, meaning the one with the actual signature of the person, the one with the wet signature, right? And you cannot present a photocopy. Under the duplicate original rule, which is now in the rules on evidence, that would now be possible. So actually, a few weeks from now, we're going to have another episode on this where we will discuss the impact of these new rules on evidence on the rules on electronic evidence, because I think there's some confusion on how those two interface. Okay. And of course, as I mentioned earlier, a document under the rules on evidence must not only be the original, but it must also be authenticated. And how do you authenticate? Okay, so first you authenticate using the rules before, which is by evidence of anyone who saw or the execution of the agreement. But additionally, if it is digitally signed, right, the fact that you can prove the digital signature, the document is also authenticated. So this is something that we put into the rules because it was our position that digital signature was a valid signature under the E-commerce Act. And if it's a valid signature, in the course of proving the validity of the signature, you're also authenticating the document. Because one of the features of a digital signature is it confirms, right, mathematically through encryption, that the document has not been altered from the time it was signed to the time that you have confirmed its contents. Okay. And finally, actually, the catch-all here is by evidence showing the integrity and reliability to the satisfaction of the judge. It's a very broad standard to authenticate an electronic document. When it comes to electronic signatures, as I mentioned, the problem is really Section 8, which we discussed earlier, a very long and a complicated provision of law. And in fact, I like to call it the Frankenstein Provision because, in fact, many parts of the Section 8 of our E-commerce Act was taken from the Singapore Electronic Transactions Act. And that law was a digital signature law. That's why when you look at Section 8, it seems to hew closely to digital signatures. Unfortunately, our law was supposed to be technology neutral. And so it creates this bizarre situation where we copied from something that is supposed to be for digital signatures, but we want to make it apply to things that are beyond digital signatures. As I mentioned earlier, at the time that the rules on electronic evidence was written, digital signatures were widely used, and our belief, at least our opinion, was that they are considered valid under Philippine law. And how do you prove a digital signature? So long as you have a method to show that they exist on a document and a method to verify. And once you show the court the electronic documents that satisfy this, then the digital signature is authenticated. And as I mentioned earlier, the moment you authenticate a digital signature on a document, the document itself is also authenticated. So it's a two-for-one deal when it comes to digital signatures. Okay, and of course, the catch-all again is that the authentication of an electronic signature other than a digital signature which satisfies Section 8 by means satisfactory to the judge would be permitted. Okay, what about other concerns, other things that are covered by the rules on electronic evidence? First is the method of proof. Now, we believe then that one of the problems of presenting an expert witness when it comes to electronic evidence is that it might be difficult to have a direct examination. Therefore, we actually put in a rule that allowed the direct examination of that witness to be done in electronic form, in affidavit form. So this is a precursor to the judicial affidavit rule. Second, we also included a provision that allowed remote examination of witnesses via teleconferencing. The only rule is that you have to apply for it and that the judge can impose conditions. So actually, that is now the basis, right, for the courts, also one of the bases for the courts to adopt teleconferencing rules in terms of moving forward with presentation of evidence. It's allowed under the rules on electronic evidence. Another rule that found its way now in the main rules on evidence is the business records exception. And this was actually suggested by Attorney Rolly Vinluan, who, because they have cases, they have cases involving corporate clients where their evidence consists of records of these corporations. And under the business records exception, you can only present electronic records or records of business entities. You have to present the person who actually was the custodian at the time that record was made. And as you know, with people changing jobs, it becomes very, very difficult sometimes to locate this person. And the Supreme Court rulings went so far as to require either that person was dead or that person is so far away that he cannot be brought back. Otherwise, that person must be presented. So now, any person or any custodian of business records can authenticate. So initially, when the rules on electronic evidence was enacted, this was an advantage to having electronic records, because with electronic records, any custodian can testify. With paper records, only you have to follow the rules, right, or the jurisprudence by the court. But now with the rules on evidence having been amended, the rule now is consistent between both types of documents. We also had to include a provision on audio, photo, and video evidence, only because in some instances, these types of evidence are really documentary evidence. They are documents. And the requirement here is that if you are presenting the truth of what you are seeing in the document, in the video or photo, then you must authenticate it. But if you're not using it to prove the truth of what is contained in the picture, then you do not need to authenticate. So a favorite example of mine is, let's say you have a case where the plaintiff, right? The plaintiff is suing because he was run over by the defendant using his yellow Mercedes-Benz. And so you are now understand and you show him a picture. Mr. Witness, I'm showing to you a picture of a Mercedes-Benz. Now, if the picture of the Mercedes-Benz is the picture of the car that was in the accident, right? And you're having the person, the witness, identify it. Now you're treating it as documentary evidence because you're proving the truth of the information contained in the picture. So in that case, you have to authenticate that document. Now, but what if you're just showing let's say a promotional photo sold by Mercedes-Benz and say, Mr. Witness, the car that hit you, did it look like this? Right? So in that case, you're not proving the truth of the content. You're using it merely what's known as object evidence. And therefore, you don't need to authenticate that picture because you're only using it in order to inform the court that this is what, according to this is what the car looked like. Not that that was the car involved in the accident. Okay? And then, of course, as part of that, we also included a rule on ephemeral electronic communications. And these are communications that, like telephone conversations or SMS messages or even email messages that are routinely deleted, they may be proven now by secondary evidence or testimonial evidence. And that's it.